Should Native American families be first in line to adopt Native American children? That's something the U.S. Supreme Court is considering right now. It would overturn 4 decades of law. 11 Alive's Dawn White breaks down the case in the next part of her series for Native American Heritage Month.
The U.S. Supreme Court heard arguments last Wednesday in the Holland versus Brackeen case. Plaintiffs say they want to make it easier for people who aren't Native American to adopt indigenous kids, while tribal leaders say it protects the welfare of Native American children. A lawsuit to overturn the Indian Child Welfare Act of 1978 is now in the hands of U.S. Supreme Court justices.
And what a lot of people might not know is that law was passed because there had been a long tradition and history of forced assimilation, which would be state governments, state agencies taking Indian children from their families and their tribes and then putting them with white families to try to assimilate them into the culture.
The lawsuit is prompted by a white couple who had difficulty adopting an indigenous child because priority is given to Native American families.
Where that gets a little hairy is because tribal courts traditionally govern adoption on tribal lands.
Atlanta area trial lawyer Tom Church believes the plaintiffs will be at least partially successful.
We have here a very conservative Supreme Court that's very interested in empowering states, getting the federal government out of the way when it comes to states being able to exercise traditional state powers like adoption.
The U.S. Supreme Court isn't expected to decide on the case anytime soon. The earliest a ruling is expected is in the spring.